your screen. This evening, Books and Books, in collaboration with the University of Miami Center for the Humanities, is very pleased to welcome back our friends from UM for the first book talk of the new season. Tonight we're welcoming Professor Kunal M. Parker, presenting his new book, Making Foreigners, Immigration and Citizenship Law in America, 1600 to 2000. And here to host the rest of our evening for us, please welcome to the podium the acting director of the center, Professor Mary Lindeman.
Thank you. Good evening. I was going to introduce myself, but as I've already been introduced, I can say that yes, I am indeed the acting director of the Center for the Humanities, while our permanent director, Professor Miyoko Suzuki, of the English department, takes up the Ruth and Clarence Kennedy Professorship in Renaissance Studies at Smith College. I'd also like to welcome you to this, the beginning of the 8th year of book talks in collaboration with Books and Books. And as always, we are extremely grateful for the use of this excellent space and for making it possible to live stream the presentations. I was going to say that Professor Kunal Parker was going to speak on his new book, Making Foreigners, Immigration and Citizenship Law in America. But maybe you're like my students and you have to hear everything twice. However, before I turn to Professor Donette Francis, who is of the English department, who is going to introduce Professor Kunal properly, Professor Parker properly, I would like to call your attention to the other 4 book talks for this semester, and you all have flyers so you can read it. The next one will be on October 5th with Professor Stephen Halsey of my department, the Department of History, who will discuss his recent book, Quest for Power, European Imperialism and the Making of Chinese Statecraft. The 3 others are also on the flyers that you have at your seats. And then I would also like to take the opportunity to call your attention to our first Stanford lecturer this year, who is the historian of medicine and science, an activist and patient advocate, Alex Drager, who will speak about her newest publication, Galileo's Middle Finger, use your imagination, Why Social Progress Depends on Freedom of Inquiry. I can promise you that evening also a lively and informative time. And now I would like to turn the microphone over to Donette Francis, who will introduce Professor Parker.
Good evening, everyone. Black Lives Matter, immigration debates, war on terrorism, gender-neutral bathrooms, white working class voters, and Native American protests against the construction of the Dakota Access Pipeline. These headlines circulate in our contemporary media, and these seemingly disparate issues which affect material bodies, Black, Latino, Asian, LGBTQI, Native Americans, and the white working class come together in Kunal Parker's Making Foreigners. I won't read the rest of his title since we've heard it twice already. As a historian, Professor Parker reaches for the big picture and significant changes over time and space, while as a professor of law, he provides a sustained close reading of U.S. case laws both at the state and federal levels. The book's brilliance is that Professor Parker brings together narratives about immigrant outsiders encroaching upon U.S. borders alongside stories about Native insiders who have been relegated to subordinate status within the nation of their birth, and shows how U.S. immigration and citizenship laws have rendered both classes of people foreigners. Given our current historical moment, where immigration debates and deportation statistics have taken center stage, his book, recently published in 2015 by Cambridge University Press in their series New Histories of American Law, is a timely intervention. It could be, one might imagine, a useful primer for Donald Trump as he clarifies his position on immigration that wavers between the absurd and going soft on immigration. Making Foreigners shows that rather than an exception, Trump's proposals actually fit into the longer historical arc of exclusions based on race and one's political affiliation. As students and citizens of American culture, the book's synthetic sweep provides a reader-friendly interpretation of American law that we can apply to our various disciplines of study, or to more generally make sense of our everyday lives and the debates that circulate in our public culture. Kunal Parker is professor and Dean's Distinguished Scholar at the University of Miami School of Law. He has a PhD in history from Princeton University and a JD from Harvard Law School. His first book, Common Law, History, and Democracy in America, 1790 to 1900, Legal Thought Before Modernism, was also published by Cambridge University Press in 2011. Professor Parker teaching areas and interests include American legal history, constitutional law, estates and trust, immigration and nationality law, and property law. If a nation of immigrants who become Americans through assimilation or acculturation has been one of our nation's foundational myths, Professor Parker invites us to reconsider how such myths of an American mosaic rely on making foreigners successive generations of classes of people the state or the nation deems undesirables. We are in for a treat with tonight's book discussion, not only because of the book's relevance, but also because of its ready accessibility. Please join me in welcoming Professor Kunal Parker.
So thanks so much, Donette, for that introduction. I'm going to sort of zip through the presentation that I'd prepared in the interest of opening up time for discussion. So stop me if I'm going too fast. Right. So over the centuries, prominent American thinkers have joined America's self-image as a nation of immigrants to its self-image as a universal nation founded upon abstract values. This powerful strand of American thinking that has linked immigration, openness, and universalism as the very ontology of the country finds confirmation in brute numbers. From the early 19th century to the early 20th, the United States drew 3/5 of all the world's immigrants, more than those received by all other immigrant receiving countries combined. The country remained the world's largest immigrant receiving country throughout the 20th century. And in the early decades of the 21st, the United States continues to admit over 1 million immigrants annually to permanent residence, more than the number admitted by any other country. In fiscal year 2011, for example, the US admitted over 1 million non-citizens to legal permanent resident status. The United States' openness to immigrants has not been restricted to opening its territory to them. Throughout its history as an independent nation, the country has adopted naturalization policies that have also been liberal relative to those of most other countries. Since the early 19th century, immigrants have been able to apply to become citizens after only 5 years of residence. This has greatly facilitated their incorporation into the polity. In the 19th century, land policies and voting laws granted immigrants valuable economic and political rights even before naturalization. If the early 21st century United States no longer grants immigrants suffrage rights, it continues to make naturalization easy, and in fiscal year 2011, the country naturalized approximately 700,000 immigrants. These numbers testify to the United States' unquestionably impressive record of receiving and absorbing immigrants. However, Americans' determined chorus of insistence upon the country's openness to immigrants should itself suggest that realities have fallen short of rhetoric. The US has never welcomed all possible immigrants. Over the course of 4 centuries, Americans have written immigration laws to exclude individuals from their territory on grounds of religion, race, national origin, health, sexuality, poverty, political ideology, and criminal or terrorist background, to name only a few of the major legal grounds of exclusion. Americans have also made it difficult or impossible for resident immigrants to accede to citizenship. From the country's inception until the early 1950s, in short, for approximately 3/4 of its history as an independent nation, race was a barrier to naturalization. If the US has never welcomed and absorbed all potential immigrants, it has also turned on those it has chosen to admit. Over the centuries, pursuant to the body of law that legal scholars call alienage law, resident immigrants have been barred from exercising political rights, holding property, entering various professions and trades, and availing of public benefits. If many immigrants were able to overcome such legal disabilities by naturalizing, those barred from naturalizing on the grounds of race would face them their entire lives. Legal disabilities have been visited with a special severity on undocumented immigrants, whose numbers escalated in the 20th century as a result of the closure of borders, the institution of numerical limits on immigration, and the complicity of public and private actors. Equally serious, long-term resident immigrants have been punished through an often callous use of deportation. Notwithstanding long periods of residence in the United States, immigrants who have sought public benefits, espoused frowned-upon political views, or engaged in criminal acts have been shipped out of the country, often to homelands they barely know, with few of the legal protections accorded criminals. During the first half of the 20th century, the government also employed denaturalization as a weapon, punishing naturalized immigrants who expressed unpopular views by setting aside their citizenship, converting them into aliens, and then deporting them. Since the immigration reforms of 1996, the country has shipped literally millions of resident immigrants, the estimate is about 12 million, to their home countries, even when such immigrants, many of whom arrived in the United States as children, are in every sense the product of American society and have few, if any, connections to their homelands. In fiscal year 2011, the United States apprehended approximately 650,000 non-citizens within the country and officially deported 400,000. Right? That year, an additional 325,000 or so non-citizens accepted voluntary departure, choosing to leave the country. That the voluntary departure is the legal term, choosing to leave the country without having formal removal proceedings instituted against them. So the gap between rhetoric and reality when it comes to how Americans have received, treated, and expelled immigrants is therefore very real. However, it's only part of the story. Over the course of American history, the impulse to regulate, reject, exclude, and remove undesirables on the grounds of race, gender, poverty, and political opinion has ranged very widely. Whether at the local, state, or national levels, it has driven communities to target insiders as well as outsiders. In the process, Americans have named and treated as foreigners not only those from outside the country's borders, but also those in their very midst. The history of immigration and citizenship law that I recount thus encompasses two intimately conjoined histories that historians do not often conjoin. That of the country's absorption and rejection of those from beyond its limits, and that of its simultaneous efforts to render foreign those within its limits. In other words, I want to join diverse histories of those inside and outside the nation, immigrants, women, blacks, Native Americans, Latino Americans, Asian Americans, and the poor. By showing how these various histories constituted one another, intersected with one another, and diverged from one another, it shows how legal categories such as alien and citizen, as well as such terms as native and foreigner, insider and outsider, and the very processes of regulating immigration and citizenship have been dynamic categories and processes necessarily understood in relationship to one another. In order to proceed, it's important to come to terms with this concept of, quote, rendering insiders foreign, unquote. In this regard, I have in mind a host of different political legal strategies that the national, state, and local governments have employed over the long span of American history vis-à-vis portions of the domestic population. These include formally designating portions of the domestic population alien, formally converting citizens into aliens for having committed specified acts, subjecting portions of the domestic population to extensive regimes of borders and restrictions on movement and residence, seeking to expel portions of the domestic population from the community, subjecting portions of the domestic population to legal disabilities comparable to those visited upon aliens, indiscriminately mingling citizens and aliens for bureaucratic purposes or in times of war, and a feature of our own time, refusing to recognize that long-term resident immigrants might, after a certain point, have become insiders despite the fortuity of their not having naturalized. Each of these different strategies of rendering insiders foreign has been deployed along axes of race, gender, and class to suppress, exploit, reject, exclude, expel, and generally refuse responsibility for portions of the domestic population. Different groups have had vastly different experiences of being rendered foreign. What all of them have had in common is that none came to the country from its territorial outside. Let me say a little bit about some of these different groups. Although Great Britain claimed sovereignty over Native American lands, Native Americans were formally designated aliens from the very first English settlement of North America. The only unmistakable naturalization in New England before 1700 was a unique act passed in Connecticut in 1695, whereby the Indian Abimelech was declared a subject of the king and granted, quote, the privilege and protection of His Majesty's laws this colony allows his subjects here, provided he takes the oath of allegiance, unquote. The motivation behind this unusual act seems to have been to clarify and settle a land title dispute. At common law, aliens could not hold or convey title to property. This was the rule both in Great Britain and in the North American colonies. Someone must have alleged that Abimelech was an alien, and as such, that he could not convey good title to property. The naturalization would have taken care of that problem. But it also reveals that Abimelech was an alien to begin with, because only aliens could be naturalized. Right? Native Americans were thus, paradoxically, America's first aliens, rendered alien not by having come from anywhere, but by having bounded communities emerge in their midst, place them beyond their borders, and designate them as aliens. This view continued after the American Revolution, and I'm leaving out all the, zillions of examples I can provide. This view continued after the American Revolution and lasted until the very end of the 19th century, and in some ways well into the 20th. In Elk versus Wilkie in 1884, the US Supreme Court ruled that the 14th Amendment's birthright citizenship clause did not apply to Native Americans living in tribes. They were, the court said, like, quote, the children of subjects of any foreign government born within the domain of that government. In other words, Native Americans born within tribes were, under the US Constitution, like Frenchmen born in France. Right? Native Americans would be granted US citizenship by statute beginning piecemeal in the late 19th century and then definitively in the 1920s. Blacks had an entirely different experience of being rendered foreign in the United States. In the aftermath of the American Revolution, slavery was phased out in the North and manumission allowed in certain southern states. The country's free black population began to grow. In some states, free blacks came to possess important markers of citizenship, such as the vote. As cotton cultivation breathed new life into slavery, and as the slavery crisis heated up, however, free blacks lost the vote all over the country except for New England, which contained only about 4% of the country's free black population in 1855. At the same time, however, although the roots of the practice go back to the 18th century, free blacks became subject to an extensive regime of territorial borders. With the blessing of the US Supreme Court, states in the North and South sought to exclude and expel free blacks from their territories. Blacks faced, in other words, a regime of internal borders far more severe than those faced by any transatlantic immigrant at the time. Right? Georgia's 1818 Act was typical. Any free person of color found in Georgia in violation of the state's prohibition on entry and residence was subject to a penalty not exceeding $100. And if unable to pay the penalty, became, quote, liable to be sold by public outcry as a slave, unquote. If such a person was found in Georgia 20 days after the payment of a penalty, the entire prosecution process could begin again. Right? In many cases, free black populations accumulated in cities in the Upper South, notwithstanding such prohibitions, but free blacks were akin to the undocumented aliens of today, right? Living, tolerated, but living under threat. And this is clear from events in Cincinnati in the late 1820s. Even though Ohio had passed laws in 1804 and 1807 imposing bond requirements on free blacks seeking to enter the state, such laws were not enforced consistently until 1829, when the rapid increase of the black population in Cincinnati alarmed city officials. City authorities suddenly announced that the laws would be enforced and ordered blacks to comply or leave within 30 days. Right? The city's black population obtained a time extension, sent a delegation north to explore the possibilities of relocation to Canada, and petitioned the Ohio legislature for a repeal of the bond laws. Emboldened by the city's decision, mobs roamed through Cincinnati's black quarters, spreading destruction. An estimated 1,100 to 2,200 blacks left Cincinnati in 1829, most of them apparently for Canada. The Tennessee Supreme Court put it thus in 1834, quote, all the slaveholding states, as well as many of the non-slaveholding, have adopted the policy of exclusion. The consequence is that the freed Negro cannot find a home that promises even safety in the United States, and assuredly none that promises comfort, unquote. While states' restrictions on blacks' entry and residence proliferated, the underlying question of the citizenship status of free blacks remained ambiguous. In 1859, however, the US Supreme Court declared in the Dred Scott case that blacks could not be citizens of the United States. Thereafter, certain Southern courts formally labeled free blacks from other states aliens and subjected them to alien disabilities such as the inability to inherit property. This is clear from the Mississippi Supreme Court's decision in Hen versus Brideau, decided in 1859, 2 years after Dred Scott. The case involved the claim of a woman named Marcellette Marceau, originally from New Orleans but resident in Mississippi, to inherit under the will of a deceased Mississippi white male with whom she had been cohabiting. The contestants of the will paraded a series of witnesses who testified about Marceau's racial status. One witness described Marceau as a, quote, bright mulatto and a free woman of color. Her son is still darker. Her hair is kinky, unquote. Another added that she, quote, never saw a white person of Marceau's color, unquote. Yet another insisted that, quote, Marceau's Negro blood is very apparent, but confessed that she had never seen her hair, as she always wore a handkerchief on her head. Now, all of this is, of course, about concealing her identity so that she could remain in the town, because, right, she wasn't allowed to be there. All of this testimony about hair and skin color convinced the court that Marceau was black. This meant that she became an alien illegally present in the state, and therefore as someone unable to inherit property under the contested will. The court offered the following rationale, quote, free Negroes in Mississippi are to be regarded as alien enemies or strangers prohibiti, and without the pale of comity and incapable of acquiring or maintaining rights of property in the state which will be recognized by our courts. During this time, as is well known, the American Colonization Society sought to repatriate free blacks to Africa. It's important to emphasize that blacks were likened to aliens, not when they were enslaved, but when they became free. Right? It was only at the point of freedom that efforts to exclude and expel them were brought to bear. After the ratification of the 14th Amendment, which granted formal federal and state citizenship to individuals born in the United States, it became impossible to designate native-born blacks as aliens or to push seriously for their repatriation to Africa. Other ways were found of regulating blacks' participation, movement, and presence. A host of measures, this is well known, of course, stripped blacks of the vote. Discrimination in all sorts of realms of life became rampant. Formal laws barring blacks from entering states' territories gave way to micro-borders of segregation that would endure well into the post-World War II period. American women had yet another experience of being rendered foreign. The virtually complete occlusion of women's legal personalities under the common law doctrine of coverture meant that their formal and substantive citizenship was deemed derivative of that of their husbands. In the mid-19th century, American men won the right to confer their nationality on their alien wives. American women, however, did not win such a right. In the view of politicians, because women lacked substantive citizenship, such as the right to vote, they had no nationality to confer, right? In 1907, Congress confirmed its dim view of women's citizenship by passing a law that stripped American women of their formal citizenship if they married alien men. Right? The law was upheld by the US Supreme Court in 1915. Thereafter, thousands of native-born American women married to aliens found themselves literally converted into aliens overnight. The consequences could be devastating. The situation of Florence Bain Gual in the early 1920s was not unusual. After 15 years as a school teacher in New York, she faced dismissal from her job because she had lost her citizenship because she had married a Cuban man. Furthermore, her husband had deserted her and her baby. She put it thus, quote, I'm the daughter of an American citizen and the mother of an American citizen, yet I'm to be deprived of my livelihood in my own country because of the citizenship of a man, unquote. During World War I, women married to citizens of the Central Powers found that they had become enemy aliens and even had their property confiscated by the alien property custodian. Property confiscated from former U.S. citizen women married to Central Powers citizens was to the tune of $25 million. American women who lost their citizenship could even be excluded and deported from the country as immigrants. The occlusion of women's legal personalities would erode bit by bit, even as women's formal and substantive citizenship came into being over the course of the 20th century. America's poor were made foreign by being subjected to a centuries-old, complex, and extensive regime of territorial borders, one whose significance for questions of immigration has not been sufficiently recognized, but which is actually central to my account. So my interest in immigration actually started with my work on the poor laws. Until the Civil War, immigration restriction was enacted at the state level, antebellum state legislation built upon colonial poor laws that did not distinguish adequately between the native-born poor and the alien poor. Both were equally undesirable from the perspective of states, counties, and towns that bore responsibility for policing borders. Both were excluded and removed from communities. When the federal government took over the regulation of foreign immigration after the Civil War, state and local poor laws remained in effect to manage the domestic movement and residence of poor Americans within the country. Warning out, as the practice was known, the colonial practice, whereby towns delivered notice to newcomers to prevent them from acquiring a settlement, which is the term for legal residence in the town, remained vital in the late 19th century. Iowa's poor law provided, for example, that, quote, persons coming into the state or going from one county to another who are county charges or are likely to become such may be prevented from acquiring a settlement by the authorities, warning them to depart therefrom, unquote. Cities, towns, and counties routinely shipped individuals to their places of legal residence as designated by the poor laws. W. Almont Gates, Secretary of the California Board of Charities, spoke at the 1912 National Conference of Charities and Correction, and he spoke of the, quote, frequently followed practice of, quote, taking an insane person into another state and leaving him at a hotel or on the street, or in fact dumping him, unquote. A 1911 case from Iowa suggests how restrictions on movement and residence bore devastating consequences for ordinary Americans. A man examining timber in the Des Moines River broke through the ice, got wet, and unable to find lodging, spent the night in a straw stack. He awoke with frozen feet. When he arrived in Boone County, he was given first aid, but following the practice of not dealing with non-residents, he was shipped on to Story County and from there to Cerro Gordo County, where he belonged under Iowa's poor law. Both feet had to be amputated because of improper care in Boone County and the county's haste in removing him. When the man sued Boone County for damages, sovereign immunity prevented recovery. So the Iowa Supreme Court concluded its opinion in the case by deploring, quote, the practice of shifting foreign paupers from one county to another as a disgrace to our civilization. Tellingly, the court's use of the word foreign paupers here does not refer to aliens, right? It actually refers to people, the foreign poor, as the term went, which was just people who are not settled in a particular place. Territorial restrictions on the movement of the poor were in fact strengthened as the Great Depression unleashed a flood of poor migrants who moved across the country in search of work. Only the recognition of a constitutional right to travel beginning in the 1940s and into the post-World War II period would definitively end the regime of territorial borders for the poor. Barriers to voting by the poor, of course, would last into the 1970s. Right? Asian Americans and Latino Americans would have the experience of repeatedly being mingled with and treated like immigrants from Asia and Latin America. Beginning in the late 19th century and extending into the 21st, immigration raids and border patrol activities indiscriminately mingled citizens with aliens, disregarding the rights of the former by treating them like the latter. Americans of Mexican descent would experience deportation, literal expulsion from the country in the state's mass deportation drives in the 1930s, and then again, albeit to a lesser extent, in the 1950s. Americans of Japanese descent, of course, found themselves interned during World War II, along with resident Japanese nationals. Thousands of citizens today find themselves caught in the dragnet of the immigration enforcement regime. And in the early years of the 21st century, American citizens have even been deported against their will to other countries. As one can see then, practices of rendering insiders foreign, and I have not discussed all of them for reasons of time, have been routine across the long span of American history and have covered diverse groups across the country. In considering these various forms of what I call rendering insiders foreign, it's appropriate to anticipate and respond to an objection. It might legitimately be observed that there has always been a meaningful difference between being a second-class citizen on the one hand and a non-citizen or a foreigner on the other. For much of American history, for example, white women were second-class citizens to the extent that they were denied political rights, barred access to various trades and professions, and subjected to legal coverture when they got married. They were not, it might be contended, considered non-citizens or foreigners. Indeed, white women were imagined and saw themselves as being at the very heart of the nation, as mothers, wives, and daughters. While I do not dismiss this objection, and indeed welcome it because it acts as a sort of imprecise limit to the scope of my argument, I would invite you to attend as well to the following. Second-class citizenship can, and all too frequently has, shaded off into formal non-citizenship, right? One can observe this at various points in American history. Thus, the legal subordination of free blacks in antebellum America and the widespread practices of excluding them from states and repatriating them to Africa easily slipped into formal assertions in certain slave states that free blacks were aliens vis-a-vis such states and subject to alien legal disabilities. The long tradition of regarding women's citizenship as subordinate to and derivative of that of their husbands led seamlessly to the view expressed in the United States 1907 expatriation law that American women who married non-citizens ceased to be U.S. citizens. By the way, this expatriation law was not specific to the U.S. It was followed by a few other countries. The second-class citizenship of free blacks and women thus literally became non-citizenship, right? We're used to thinking of the history of citizenship as a progression, according to T.H. Marshall, of the acquisition of civil, then political, then social rights. Marshall, of course, famously ignores the citizen-alien distinction, but history shows that being a second-class citizen can shade off into becoming a non-citizen. More frequently, strategies of rendering insiders foreign had the effect of impressing upon those affected that they were foreigners vis-a-vis their own country, even if they did not lose formal citizenship thereby. Some feminists in the 19th century expressed the view that as second-class citizens, American women were akin to aliens. I'm thinking of people like Angelina Grimke actually has the speech given to the Massachusetts legislature where she says, are we not aliens? Are we aliens because we can't participate in the political affairs of the country, right? In the post-Civil War years, blacks were formal citizens of the United States. However, their second-class citizenship convinced some that leaving the country and returning to Africa was their only option. Back to Africa movements captured the imaginations of intellectuals and others in the late 19th and 20th centuries, even if the numbers that actually repatriated were very small. Japanese-American internees during World War II understood perfectly well that their formal citizenship had not prevented them from being treated like aliens. Many repudiated their US citizenship and repatriated to Japan after the war. In other instances, subordinated groups might not express their sense of foreignness vis-a-vis the nation, but a cursory glance at the substantive legal deprivations they suffered points to far greater substantive similarities to aliens than it does to citizens. So what happens if we reimagine American history through this concept of rendering insiders foreign? Instead of thinking of America's subordinated groups as incipient citizens in the making, categorically different from foreigners at the gate, which is how much US citizenship history has been written, we might think of them instead as being, at various historical junctures, internal foreigners. Their foreignness was thrust upon them even though they had never crossed an international border and had been in the country all along. This suggests that foreignness, even formal legal designation as alien, has less to do with where one is originally located vis-a-vis the territorial polity than it has to do with an originary refusal, right? A gesture of rejection. Recognizing the ubiquity of American practices of rendering insiders foreign is a stepping stone to understanding the history of immigration and citizenship. And in this book, I trace how we move from an early modern world, a world of multiple legal statuses, in which the distinction between British subject and alien was relatively weak, and in which it was possible to be a native-born alien, to the world of the early 21st century. The book reveals an arc, or the arc, of a halting and sometimes reversible extension of formal and substantive citizenship among the native-born population, a hardening distinction between citizen and alien, and a centralization of governmental regulation of the alien under the auspices of an increasingly powerful state. This arc is paralleled by the transition from a highly decentralized polity in which towns, counties, and states enforced borders vis-a-vis those from other towns, counties, and states and foreign countries, to a centralized polity in which towns, counties, and states are barred from wielding borders vis-a-vis those inside the country, while the federal government monopolizes the wielding of borders against aliens, right? Along the way, one observes multiple intersections and parallels between ways of absorbing and rejecting outsiders and ways of rendering insiders foreign. Although far too numerous to discuss here, one worthy of mention has to do with the intimate and not often sufficiently highlighted relationship between slavery and immigration. Before the Civil War, slave states anxious to preserve slavery were insistent on their right to exclude free blacks from their territories and fearful that conferring immigration powers upon the federal government would strip them of that right, right? So despite tensions during the antebellum period over the proper locus of authority to regulate immigration, therefore, a federal immigration regime focused on regulating aliens' access to and presence within national territory would not emerge until the slavery issue was resolved. And this is actually quite clear from the Supreme Court's discourse on the issue, right? So at the end of 4 centuries of American history, as one traces the twisting path that has come to separate insiders from outsiders and given rise to a powerful immigration state, the immigrant has emerged as a lonely legal subject, right? One uniquely marked with a set of legal and territorial disabilities that he or she once shared with many insiders and that now distinguish him from them. Today, immigrants are the only ones rejected in certain ways because the rejection of outsiders in such ways has been rendered more difficult or impossible. Because the rejection of insiders, that's what I meant to say. This is not a clean historical narrative. The older hierarchies through which insiders used to be rendered foreign have had a very long half-life, but the narrative holds. So the value of the approach that I adopt, if it has a value, that of tracing the history of strategies of rendering foreign that applied both internally and externally, is that it allows us to capture changing understandings of citizenship and alienage, inside and outside, domestic and foreign, over the long span of American history, but it also complicates entrenched renderings of Americans' responsibility to immigrants. There's been a powerful tradition in American political thought that has made the case for closed borders vis-a-vis immigrants on the ground that our primary responsibility must be to citizens. Thus, decades ago, the liberal political thinker Michael Walzer famously argued, quote, "Neighborhoods can be open only if countries are at least potentially closed," unquote. The claim is that we can fulfill our commitments to our neighbors, citizens, only if we exclude strangers, aliens. This line of thinking maps perfectly onto a venerable positivist tradition in international law that authorizes states to close their territories to those from other states. And this tradition has long been endorsed by the US Supreme Court. But in showing that the citizen-alien distinction, together with the myriad meanings attached to it, has a long and twisting history, this book calls this line of thinking into question, right? If we look back at the historical record, can we be sure that terms such as citizen and alien can map neatly onto terms such as insider and outsider, or neighbor and stranger? Over the centuries, Americans have named as aliens immigrants, but also blacks, Native Americans, and American women married to aliens. They've rendered foreign not only Asians and Latinos, but millions of Asian Americans and Latino Americans by lumping them in with immigrants of the same national background and removing them from communities. They've sought to absolve themselves of responsibility and hence to exclude and remove not only poor immigrants, but poor Americans from nearby towns, counties, and states, indeed, their very next-door neighbors. And I have a paper on exactly that subject for the late 18th century. It's a paper on town division and how that worked. This record suggests that we not fall into the facile trap of fetishizing space, of allowing our sense of what we owe to neighbors and do not owe to strangers to turn on something as crude as pure physical presence or absence, which I want to suggest are always politically and legally mediated. Americans have long imbued presence and absence with political and legal meaning, marking Native Americans as aliens and placing them beyond the borders of their communities, for example, while welcoming European Protestant settlers into their communities as proto-citizens and giving them property and political rights even before they naturalized. By reminding us of the fact that we, quote, we on the inside, blacks, Native Americans, women, the poor, and others, were ourselves once rendered foreign, I seek to provoke a different relationship towards immigrants, those in our midst and those beyond our borders. And I want to suggest that they, like the heirs, like us, are the heirs to the many struggles that have made this country what it is. So I'll end there. And yeah. Dominique.
That was so rich, so actually I just want to know more. You start with what's so impressive about the American record in terms of an immigrant receiving, and then the talk, if I close my eyes and cut out a couple words, sounded like the rest of the world.
So it's not about, so there's certainly been a fair number of books and certainly a literature trying to think of America as a society of settlers, right, and producing that kind of narrative. This is not. So I would say that sort of if you scratch the sort of lawyer in me, like I think the enemy here for me is plenary power, like the constitutional regime that actually vests plenary power over the lives of immigrants in the federal government and exempts it in many respects, although not all, from constitutional constraint. So it's really about trying to chip away at that sense of a divide between us and them, or immigrant and alien and citizen, and so on and so forth. So, I mean, unwittingly, I mean, it is a story as well, but I think you can really only retrieve that story of sort of domestic foreigners if you go further back, right? Because there is a kind of the formal legal status spreads and sort of picks up more people and changes in importance as well. Yeah.
Religion was the one category you didn't speak much about. I was wondering, is it in the book, or why did you choose?
It's not really in the book, in part because, so there's, I mean, well, it's in the book to the extent that I talk about nativism. But of course, religion has not been a formal ground of exclusion. Certainly in the 18th century, you see some references to it when you're talking about sort of Catholics. But in the 19th century, there's certainly a lot of anti-Catholic nativism, but it actually works through the poor laws, right? So, and there's certainly events like the burning of the Ursuline convent in 1834 and so on and so forth. And then in the 20th century, there is some work done on deportation directed at specific religious groups, also some work on how exclusion bars like the ban on polygamy was used against immigrants from the Ottoman Empire and stuff like that. But that work has not really been done in a serious way, I would say, right? Sure, yes, yeah.
So today we see a lot of like Central American and Mexican immigrants who are in every way, integrated in our culture and the insights that you talk about, except for actual citizenship status. So would you consider that as like a historic progression of this trend, and also what other manifestations do you see in like our present?
I mean, I would see it as a sort of exemplification of this trend rather than a sort of any kind of progression, right? I mean, so I think the ways in which deportation works, post-96 particularly, with the removal of reviews, the possibility of review, the lifting of the banning of waivers and some mandatory deportation, you see a lot of people who actually have come to this country as children, right, but who never naturalized, who are shipped back. And so there's work done by lots of people on not only on Americans caught up in the dragnet who find themselves in Mexico, right, deported, but also on the reconstitution of American gangs in countries in Central America, right? So there's a lot of work on that kind of thing. And there was a second half of your question that I...
What other manifestations do you see?
I think this is a rubric that I think could be used to describe many things, not just in the US, but elsewhere. The denationalization of Haitians in the Dominican Republic, right? That would be one example. But I also read an article, and Stephen will correct me if I'm wrong, which was very interesting in the New York Times about the legal disabilities on children in China who were born in violation of the one-child policy, right? In terms of their inability to get jobs, legal residence, and so on and so forth. And there was an interview with this woman who said that she was sort of in hiding, right, in a way. And so I'm not saying that that's a sort of, direct analog of what I'm talking about, but I think there are many such statuses in many places. Right, Stephen.
Yeah, as I listened to your talk, I could not help thinking about Uday Mehta's liberal strategies of exclusion. And in it, he's basically arguing that not just that liberalism leaves certain people out, but that in some sense, strategies of exclusion are a condition for the possibility of the liberal project itself.
Mm-hmm.
Is that, in fact, a fair characterization of what you're talking about? Is exclusion a condition for the possibility of the American liberal project? And secondly, is it analytically useful, if the answer is yes, is it analytically useful to compare the U.S. case with what Mehta's talking about? He's thinking about the construction of British liberal subjects and a colonial context, specifically South Asia.
Right.
So does the comparative move
So that wasn't actually what drove me to do this, partly because I think and it's been a while since I read that book, but he doesn't actually talk about, I'm really interested in literally a legalistic rendering foreign, right? So it's not simply about subordination. And so we're very used to writing histories of US citizenship in terms of subordination, and I occasionally tell my students, it's the narrative is presented as, the cinematic image of someone running on the platform to catch the train, and of course everyone gets on eventually, right? This is kind of Roger Smith's Civic Ideals, is that kind of project. I'm sort of not that interested in that version of it, and Udemeta's not either. I mean, he has a more critical thing going on. I'm actually interested in how foreignness works. So I'm actually interested in, could you be literally rendered an alien, and when I say alien, I mean the legal category of alien, with its attendant legal disabilities, with its attendant disabilities on movement and residence and holding property and entering into contracts and all of the stuff that you see in the 19th century. Could that happen? And I don't think that Udemeta is interested in that, which in some ways what I'm doing is less grand than what he's doing, but in other ways I think it's not something that liberal theorists really talk about. Well, they do, but they don't actually do it in a kind of historically sustained way. There's a particular liberal take you get on immigration, which you can sort of imagine. But. All right.
Do you think that these legal actions are reflective of, like as you said, objective morality, or more reflective of like the collective normative set of morals, say in America?
An objective versus a collective? I think that it actually responds to, I would say, many, many different imperatives, right? So the imperative of controlling the poor is actually different from the imperative of rendering women foreign, which is, again, different from the strategies of talking about Native Americans as aliens. So I think there are multiple things going on. I think one of the things that I was trying to do in the book was kind of bring those together and actually see how the immigrant sort of emerges, right, out of a welter of restrictions with different logics that apply to different groups, right? So the challenge of writing a book that was supposed to be short and trying to do this is, everything gets sort of a couple of sentences, right? Then you got to move on. But so I didn't think of them as being sort of one logic. I should also say that one of the things that I've been accused of correctly is not really writing a history of resistance, right? So it's not really a history of people fighting back and overcoming. So that overcoming is just sort of represented in the next chapter as a sort of change that happened. Right? But it's really not about dwelling on that moment of struggle. Yes, Tracy, Donna, and then, yeah.
In as much as the long arc of this history shows us all of the injustice and the exclusions that have occurred in the different ways that you've laid them out, and one of the points of your book is to make us think about the current situation. What, to kind of ask you to make a normative argument, would be the just reasons for exclusion that one might take from this long story that would help us think about a legitimate way of determining who comes in and who gets to stay under what conditions and so forth?
So I think that those, that's a harder question because I'm not, I don't ever expect to be hired as a consultant on that issue, right? Like this is kind of not my career ambition, and I would not be good at it. I'm kind of better at taking apart what other people build. So having said that, I do think it's fair to say that the current situation is problematic on multiple levels. So the fact that we have numerically identical country quotas for countries of vastly differing size, so you can be from the Philippines or Liechtenstein and you still have the same number of people who are allowed to enter the US every year. that produces a situation where Filipinos wait for 20 years to get a green card, which then exacerbates the problem of undocumented immigration, which then leads to the problems of deportation and the breaking up of families, of mixed status, right? So there's really sort of multiple things you can talk about. The other thing that I would think about is the deportation regime, the detention and deportation regime post-1996, which has been devastating for immigrants and their families. So it's not just, I mean, the other way of blurring the distinction between inside and outside is actually to talk about how those acts of designation and treating foreigners as such actually have real impact on Americans. Right? So that's what I would say. But I mean, am I capable of actually coming up with, you know, the new legal immigration regime? I mean, I could try, but like anybody else, but that's sort of not what I'm doing. You know, yes.
In your book, do you look at the situation of American expatriates who live long periods abroad and how they might or might not be rendered?
I don't look at that a lot. There's some mentions of it, but you know, the U.S. Government sort of got into the habit of expatriating Americans against their will in the early 20th century. So it became a strategy for managing not only problematic immigrants, but also immigrants, but also Americans who voted in foreign election, who served in a foreign military, et cetera. Some of those efforts, well, it's fair to say that those efforts were really cut back on as a result of pronouncements by the U.S. Supreme Court.
What I really meant was Americans who voluntarily moved abroad for business reasons
Sure.
and lived very long periods
Right.
of time.
So, I mean, so the short answer is I don't really talk about that, but I do talk about limits on involuntary expatriation, because to me, involuntary expatriation is another way of making foreign Americans, right? And then that sort of is cut down on in the 20th century. Donna.
So I know you're focused on legal definitions of alienage, but as I listen to you talk about the disabilities of being an alien, I can't help but think that we have this big population in this country who have many of those disabilities. The right to travel is certainly limited. They have less protection, less Fourth Amendment protection. They can't vote.
Right.
And of course, I'm talking about people who are subject to the criminal justice system or so forth, and who are, at least in theory, have constitutional rights.
Right.
And so I guess more of a comment than anything, but I wonder if there's if that's an interesting kind of parallel, and if that raises questions for if the plenary power is your thing you want to defeat, then clearly we're perfectly capable of ascribing all of those many of those kinds of limitations on a population that have constitutional rights.
I actually talk about that so the last chapter of the book is called "A Rights Revolution?" Right, and it actually ends with comparing the mass deportation post 1996 with the mass incarceration, right, post 1980 circa, and thinking of those parallels. But when I say that the enemy is plenary power, actually the point is not actually to make everyone a citizen, right? Because that's not the pot of gold at the end of the rainbow. It's really that the imagined valences we give to that distinction need to be drawn into question. It doesn't mean that actually becoming a citizen could actually be not a great thing in some registers, but it's also important to note that the people in prisons do not face deportation, right? There are certain things that cannot be done. And this was said in the 1930s by a welfare administrator, which I thought was a very telling quote. He says, the Mexicans we can deport, the blacks we cannot deport, right? So that's the sort of, if you want, that's like the book in one sentence, right? Like that actually tells you what that history is, right? Yes. Yeah.
So I was wondering if your book could provide a support or an argument for the expansion of access to counsel for people in deportation proceedings because of the desperate, the very unbalanced. I mean, in criminal defense, there's a fair
Well, it's a critical part of plenary power that deportation is a civil sanction, right? So you do not get the legal protections that you get if you're in a criminal proceeding. And that has been used by the government since that idea emerged in the late 19th century quite effectively against immigrants, right? I mean, it's much better now than it was before before World War II, but that's an important part of what plenary power is, right? So yes, how much time do we have? You should,
One more question.
at least one more. Okay. One, yes.
I was just curious, would you consider your book more of a historical perspective of how the plenary powers have dealt from a legal perspective of changes in ever-evolving norms and values of what they considered to be just, or would you consider it more of a critique of all of these evolutions within the legal system of the United States towards immigration from almost the prism of today's?
So the book is actually not about plenary power, right? The plenary power emerges at a particular point in American history and in the narrative that I tell quite late. So if there are 6 substantive chapters and plenary power emerges in the 4th, right? So it's a late 19th century invention. But of course, ironically or not so ironically, an analog of plenary power is also extended at the same time to Native Americans, right? So Native Americans also get subjected to essentially an extra constitutional regime, which is the same version that gets extended with some complications to the colonies acquired after the Spanish-American War. So there's once again, it's not simply something fixed on immigrants. It has a reach. It's part of the new language of sovereignty that emerges in that period, I would say.
You had mentioned denial of citizenship to Native Americans. What about the status of citizenship for other conquered peoples as we moved west, like Floridanos after 1823 or the Californians after 1846?
Oh, so citizenship is extended by the Treaty of 1848 to all Mexicans who remain in the acquired territories. So they don't, I mean, they can, if they choose to leave, but if they stay, they're deemed to have become U.S. citizens. Yes.
So my question kind of carries on from that. I mean, the context that you're talking about, the historical context is one of empire, right, of expansion to the west. And there seems to be this sort of countervailing force of inclusion at the same time that there's this attempt to exclude and create foreigners, as you're saying. So my approach to this is Jane Cooper and Jane Horvath and Fred Cooper, who read about empire, and one of the aspects of empire is the creation of difference. I mean, that's how empires have sustained themselves, by creating different communities that have different privileges and rights. So my question would be, so how do you see any potential for this universal liberal citizenship that sort of exists in theory but never actually exists in practice from this 400-year sweep that you're talking about? Or, I mean, the liberal regime is sort of is a very small period of time in the broad sweep of history. And the question is, do you really see the potential for this to be carried out in fact, that the universal liberal citizen who has equal rights, de facto as well as de jure, will actually ever come into existence?
No, I mean, I don't. Are you asking me what I see as a kind of deep commitment of my own?
Put on your seer.
Right. So I tend not to do that very well. So I mean, I'll just say that for me, it's really about a kind of history of repeated exclusions that I want to draw. Right. So again, I'm not really interested in narratives of completion or fulfillment, or I'm just kind of more interested in how these very ugly fabrics keep getting recreated.
And we can continue on and on. But let us think.
Thank you for coming.
All right, folks. So, wow. If there are no more questions, if you are interested in acquiring a copy of Making Foreigners, you could visit the counter in the front room over there, and we can take care of you. I want to thank our introducer this evening, Professor Donette Francis. I want to thank our friend, Professor Mary Lindeman, for hosting the night for us. And please give another warm applause for Professor Kunal Parker. Thanks very much.